then NLNG, Lois Oni, and Olayinka, all the work they've done in cooperating with us to put this together. Special thanks also goes to our speaker for today for putting the curriculum together and also for accepting to lead on this groundbreaking initiative. Our guest speaker is Chinedu Ihenetu Geoffrey. I'll introduce him very shortly, formally very shortly, but just for the sake of housekeeping, I'll please ask that people put in their questions on the Q&A box. You don't need to send messages on the chat box unless you have to. Don't tell us where you're from, your branch, the normal things can be a bit distracting. And so this is the first session of our project finance course, and it's going to run through 10 modules. This is the first module. With this module, we expect that you at least understand the basics about project finance. The other modules will have to inform you about as we move along in terms of the time and dates for delivery. But so that I don't take too much of your time going forward, I'll just introduce Chinedu, who is our guest speaker for today. Chinedu is a senior associate in the Energy, Natural Resources and Infrastructure Group of Allen Overy Sherman Sterling LLP, and is based in London. He has extensive experience advising project sponsors, governments, banks, ECAs, IFIs, DFIs, multilaterals, and other financial institutions on the development, construction, and financing of complex energy and infrastructure projects across multiple sectors in Africa, in particular Nigeria, Europe, and Middle East. Chinedu is a Nigerian national and dual qualified in England and Wales and Nigeria. He was voted Rising Star Lawyer of the Year 2024 International Practice at the IFLR African Legal Awards 2024. We'd had previously worked with Chinedu when we did a training with Allen and Overy on digital transitions. And we found that he's a very dynamic, very resourceful person. But all I'll say is that we've had about 20 people who've worked with him in the past. And each person just comes back to me and uses one word. They all say Chinedu is solid. So, distinguished colleagues, delegates, it's my pleasure to welcome Mr. Solid to today's session. Chinedu, we'll just have you, once the training is over, then we can take questions. And I can come back when you're done. Thank you. The floor is now yours. Thanks.
Thank you very much, Tobena. It's my absolute pleasure to be in the midst of distinguished members of the Nigerian Bar in the audience. It's such a big pleasure to have the opportunity to be giving this presentation, and thank you to the organizers, TPLA, NLNG. It's really appreciated. Tobena, that's a big shoe to fill in terms of your introduction, but hopefully I will try and do justice to the topic that we have in front of us today. As Tobena sort of highlighted at the start, this session is intended to be a high-level overview of project finance. It's not intended to be an absolute deep dive into every aspect of the concept, but essentially it's just to sort of give people a flavor of what project finance is all about, particularly for those who are not familiar with this area of law or who are looking to expand their wealth of knowledge. I'm also conscious that there are people in the audience who are very knowledgeable in this particular field of law and actually then want to sort of improve on what they know or gain a bit more experience in terms of some of the experiences that I've had advising on deals globally. So without further ado, I will go straight into it. So hopefully people can see my screen. So essentially what we are going to cover, like I mentioned at the start, is we're going to talk about what project finance is. We are going to briefly touch on different sort of project structures that we tend to encounter from time to time, who the potential parties might be in a project finance context, and their various motivations and objectives. And then we will briefly explore some of the debt structures that we tend to see put in place when we are having a project finance transaction. And then the overarching transaction documents that underpin the project finance debt structures that we put in place. And then finally, we'll touch on the concept, the nebulous concept of bankability and what that actually means in practice and how we can get a project to be bankable and what that entails in terms of risk allocation and who are the right parties to bear a particular type of risk in a project finance context. And then hopefully at the end, we can take questions. So what is project finance? I've tried to put on the screen a very simple definition that was provided by a leading authority in the field of project finance, Graham Vinter. And essentially what he said is project finance is the financing of the development or exploitation of a right or natural resource or an asset, where basically the bulk of the money that is used for the financing of that asset does not come from share capital, but instead repayment of the money is principally sourced from the proceeds generated from the project in question. And if you look at this definition, if we try to unpack it a little bit, what we are really talking about is you're not talking about an asset that is being financed from equity predominantly. There could be some equity in there, or in most cases, there is always equity involvement in a project finance context, but majorly, the sponsors or borrowers in a project finance will typically look for high leverage. And depending on the sector that you're playing, you could have, depending on the sector that you're playing, you could have leverage anywhere from 70 to 80% of the deal size you're looking at. And from the equity perspective, you also have project proponents looking to drive deals at the sort of 20 to 30% equity mark. Again, like I said, it largely depends on the sector in terms of the gearing. And then going back to that definition, again, what Vinter was saying is that a project finance entails little or no recourse to the project sponsors. Essentially, all you're getting as a funder is the cash flows generated from the project that is being constructed, or the web of contracts that you can get, or the security package that you could potentially source. But there is little or no recourse to the sponsors or the project proponents who have put together the project. So by that, you can already see how risks are presented to whoever is looking to finance a project. And the reason why that is the case is that most of the time, the project company or the entity that is borrowing the money is an SPV, a special purpose vehicle, that has no assets, has no cash flows, and essentially the assets it will have is the project that it is looking for money to be able to build. And therefore, there is heightened risk from whoever is the financier that is providing the funding to sort of try to do some deep bankability analysis to look into some of those risks. And so the sort of the sum of all of this is that the debt would essentially be paid out of the proceeds or the cash flows generated from the project. The risk that the banks will be looking at is essentially, how can I get this project to be able to generate the cash flow that will be sufficient enough to pay the underlying debt? And the sponsors, from their own perspective, will be looking at how are we able to structure this project such that it not only repays the debt, but also potentially leaves some upside by way of dividend or distributions for all of our stress. And then that leaves a lot of structuring going into all of this to make sure that the security package or the collateral framework that the lenders who are funding the project will be looking to structure is watertight, to be able to give them sufficient protection in case, for whatever reason, the project doesn't get built, or they need to sell the assets of the project. Now, oftentimes you hear a lot of different types of terminologies, corporate loans, project finance. What we are trying to achieve on this slide is to sort of explain in simple terms what the key differences are between a project finance and other types of financing. And so, as I explained earlier, you have a project finance where you're strictly relying on the cash flow generated by the project to be able to repay the debt that's been borrowed for the project, versus a corporate finance where essentially you're lending on the basis of the cash flows or the existing cash flows or the balance sheet of the borrower. So the borrower might be an operating business or a business that already has sufficient cash such that the lenders in a corporate finance world are not reliant on the cash flows from the project to be able to repay the loan. There's also the sort of distinctive feature, which is that in a project finance context, is really targeted at a single asset in a single sector that is being financed. Whereas, in a corporate context, you're looking at the broad revenue streams of the business of the borrower, and you could potentially source different sorts of revenue streams from different types of business that the borrower has in order to repay the debt. And so what that then leaves you is a high degree of flexibility to be able to take on more debt in the context of corporate finance, particularly if the borrower is a strong borrower or has strong cash flows that can accommodate increased indebtedness. Whereas in a project finance context, you could find that there's a lot of constraints on the ability of the borrower to take on debt, because essentially the debt is being benchmarked on the revenue stream that is generated by the project. So lenders are a lot more tight and stringent in giving that flexibility. When and how is project finance used as a context? You can use project finance essentially to finance any project that the borrower is looking to build and operate. So this could come in various forms, whether it's a refinery, whether it's a fertilizer plant, or social infrastructure such as schools, hospitals, or it could be sort of hardcore infrastructure like roads, rails, deep sea port, airports, or it could be sports stadiums, etc. So whatever the project is, you could potentially invoke a project finance structure to be able to finance it. I would like to make two final points in this particular section before we move on to the other one, which is in thinking about structuring the financing of a project, it is important to look at it from a holistic perspective, in the sense that you're not just thinking about the construction of a project. You're thinking about how the project would operate. You're thinking about potentially expanding the project in the future. You're thinking about how you can refinance the construction debt that you use to build the project in the future, potentially to fetch better terms if the project is doing really well during the operations phase. You're also potentially thinking about a portfolio management perspective where you could sort of bring the particular project that you're financing together with other projects that you have in a pool, again, to be able to access better financing. You're also thinking about what could potentially happen if you come to the tail end of the project, for example, a mine, a gold mine, or a copper mine, where essentially there is a sort of a terminal life to the project. You're thinking about your obligations in terms of decommissioning and what you need to do by way of meeting your decommissioning obligation. So there needs to be this sort of cradle to grave approach, if I can use that life analogy, whereby the initiation phase of the project at the conceptual phase is the start, and then you talk about the planning, you talk about how you can go about procuring the project, putting in place financing, and then building the project, operating the project, potentially selling the project or acquiring another project, and then refinancing it if the project is up and running and you are at the stage where you can attract cheaper debt, or you could look at expanding the project. Say it's an airport project that you started off with limited capacity. You could look to, as the project is doing well, you could look to sort of expanding the capacity of the project so that you can take on bigger traffic of people. And then, ultimately, when the project comes to the terminal end, you can look to decommission it. The final point I wanted to make for this particular section is that sometimes you find this terminology is being used: greenfield project versus brownfield projects. What do these actually mean? And in simple terms, when you're talking about a greenfield project, what that means is basically a project that you're building from scratch, that is new. Nothing else is there on the site. So this is the first time something of that nature is being constructed, versus a brownfield project, which might mean an existing project that you're trying to increase capacity on, or you're trying to expand the project. So that's essentially the difference. And in the context of the previous slides that I just described, whether it's a greenfield project or an expansion project, you need to be looking at the life cycle of the project from a holistic basis when structuring it. Having explained in a nutshell the overview of the project and sort of how that could be potentially structured. Now, the next topic we're going to go into is the different types of common structures that we tend to find in a project finance transaction, and who are the relevant parties that often participate in a project finance context, and their varying objectives and motivations. Now, it is important to mention at the outset that there is no hard and fast rule here. The structures I'm going to explain in a minute is not a one-size-fits-all structure. So the structures could vary depending on the sector. It could vary depending on whether you're talking about a single project or multiple projects that are integrated into one single framework. So, this is not a one-size-fits-all approach. But at the basic core of a project finance structure, what you have on your screen is what we will typically see on some of the transactions that we encounter. There at the core of the screen, you find your project company, who is essentially the special purpose vehicle that have been incorporated in order to construct and operate this project. And at the top left-hand side of the screen, you have the sponsors, who are the project proponents that are sort of backstopping or supporting the project that the SPV is putting together. So essentially, you have your sponsor putting in place equity commitments, either by way of share subscription or shareholder loans into the project in order to effectively capitalize the project for the sort of early phase works. And then at the top of the project company, sometimes, but not always the case, you could find government involvement in projects, particularly where there is need to grant certain rights to a project company. And I'm speaking something like a port project or a road project where effectively roads fall within the purview of governments, and therefore there is need for government to grant some rights or concession to the relevant project company to be able to build and operate, and ultimately in the future, depending on the structure that has been adopted, transfer out the roads or the ports that is being constructed. So that is being implemented usually by way of your concession agreements, or if it's a PPP project, you could have a project agreement. But essentially what that document is doing is to get the government to make some promises and to grant some rights to the project company to be able to construct and operate the project. On the top right-hand side of the chart, you can see your suppliers, and this is where essentially the project needs raw materials to be able to be built, and therefore the project company needs to source that raw material or sort of feedstock that goes into what is required to be able to build or construct or deliver the output that the project facility will generate at the tail end of it. And so often you find that the project company enters into some form of supply arrangement with the relevant suppliers to be able to get that raw material. On the sort of immediate left-hand side of the screen, you have the contractors, the construction contractors who are there effectively to construct the project. And so they enter into a construction contract with the project company to be able to build the project. At the bottom left-hand corner of the screen, you find that once the project is fully built, it then gets operated, sometimes by a third party called an O&M, an operation and maintenance contractor, who enters into an operating and maintenance agreement with the project to be able to operate the project. A lot of the times, depending on the sophistication of the project company, the project company could potentially do this in-house where they have the capabilities to do so, or otherwise they will contract it out to third-party O&M contractor. And then, at the core of all of this are the lenders who finance the construction of and operation of the project. So the banks, this could vary depending on the number of financial institutions involved or the structure of the financing being contemplated. There are a number of different lenders that can come into the project, starting from commercial banks to development financial institutions to multilateral financial institutions to credit funds or private equity funds, etc. There are different degrees of lenders that could potentially loan to the borrower. And then finally, at the right-hand side, bottom right-hand side, you find the offtake contract, who would effectively, which is a contract that will be entered into by the offtaker, who essentially will buy up whatever is the output or the products that the plant that is being constructed generates, and then in exchange pays cash to the borrower, and that cash effectively then forms the relevant sort of monies that will go towards paying down debts, and ultimately being used as distribution to the sponsors. Again, that is a fairly simple basic structure. There are various degrees and iterations of this structure that you tend to find in projects, depending on which project it is or which sector, etc. So you have a PPP structure here involving government and private sector participation. You could also have a slightly different structure in a power project where you have a fuel supplier and contractor and the entity that is purchasing the power through a power purchase agreement. You could also have a holdco financing structure where essentially you have a JV, whether incorporated or unincorporated joint venture, who sort of put together funding or equity arrangements in order to build a project. Regardless of what the structure of the project is, one thing is clear, that you generally tend to find these parties involved in the project. Not all the times, but a lot of the times you find part of or most of the parties on the screen being involved. And then I think the point we're going to make next is that each party that you find on your screen have a particular motivation or objective that as to why they are participating in the project. And we'll just pick up a few in the interest of time. The first is the government. Why do you find governments involved in project finance transaction? The reason is simple. There is a lot of pressure on the finances of governments. And so, in order to sort of de-risk or sort of reduce the pressure on their balance sheet, they often try to partner with private sector participants who can help provide capital in order to build out public assets or provide services to members of the country, so citizens of the country. There's also economic development, which can be a critical part of their governmental agenda that you tend to find also is a way for government to potentially find foreign investors who are looking to come into the project to develop infrastructure in the project. Sponsors also come into projects for a number of different reasons, depending on the nature of the sponsors. Sometimes you could find construction companies, sometimes you can find oil and gas companies or equity investors, etc., depending on their nature. But essentially, their goal is simple. They want to maximize the ability to extract profits from whichever country or assets that they are investing in. They want to be able to potentially generate fees if they are coming in at a slightly different part of the value chain. Maybe they are coming in as part of the EPC construction consortium, or potentially coming in on the O&M operating side. That helps them to generate some fees. It could also be that as a strategic corporate focus for them, they want to probably enter into a particular sector, and so they feel that a way to potentially access that sector is to finance or support the financing of the project. But also one of the critical elements, depending on the nature of the sponsor, is also to potentially find an exit strategy in their investments. And you find this through their sort of share transfer restrictions and the ability to retain control or to cede control, depending on what their sort of overarching mandate is internally. Funders. So we spoke about funders who are very critical in a project finance value chain. And essentially, depending on what their mandate is, for example, commercial banks and institutional investors, these guys are mainly there to be able to maximize returns, either by way of the margins that they are able to get from the loans that they make to borrowers, or potentially, to be able to benefit from the upside to build out their credentials in particular sectors. But most of the times, commercial banks tend to see themselves as from a risk perspective as sponsors. So as much as possible, they want to maximize risk. They want to be able to call on the loan if for whatever reason a project has not gone according to plan. And this is sort of in contrast to some other types of lenders, such as development financial institutions, who have a slightly different mandate in the sense that they're a lot more sort of development focused. They are there to advance the development of emerging markets, to be able to make sure that the country is doing well and that people those countries sort of achieve in industrialization and their citizens are well off in comparison to other developed markets. You could also find that DFIs tend to offer cheap debt in comparison to commercial lenders. And then on the other side, export credit agencies are also there to participate in project finance transactions, partly to promote export of goods and services from potential exporters in their home countries. And so, you can start to see how the different agenda and objective of these institutions can drive this sort of negotiation tactic that they can deploy in a project finance context. Bondholders, are also another potential source of funding who participate in project finance transaction. And so, you find that they are there to be able to access, increased yield, either by way of fixed returns or potentially index sort of linked instruments. And they are there to, get repaid, towards the tail end of the financing. Now, so having sort of talked about what project finance is, having sort of explored very briefly different types of project finance structures that you could potentially find, we are now sort of moving into the sort of the third limb of this discussion, which is to discuss if we're looking to put in place debt financing to be able to construct and operate a project, what sort of different debt structures can we see or have we seen in the market, and who are the major players in that context? And again, it's fair to say that the type of debt structure that is put in place will largely depend on the sponsor's goals and objectives, and it could also potentially depend on the sort of the sector and the risk appetite of the various parties to the project. So, for example, you have on your screen, you could have a very straightforward bilateral facility, which is entered into a bilateral loan facility, which is entered into between a lender and a borrower, whereby the facility is unsecured in the sense that there is no collateral that is backing or backstopping the facility. So essentially, the lenders are heavily reliant on the cash flows that the project generates to be able to repay the loan. They are not reliant on being able to take some collateral to be able to sell and generate some returns to maximize their recovery. And so you can imagine in this sort of unsecured bilateral facility context, there will be a lot of scrutiny in terms of negotiating a very robust structure in this context. Another structure that we can also see in project finance context, it's a bilateral facility between one lender and a borrower, whereby you find that the borrower will be providing security as part of the overarching lender protection for the financing. Sometimes you could also find that the shareholders or the sponsors who are sitting behind the project also provide some form of support, either by way of guarantees or debt service undertaking. So in this context, what you find typically is that the borrower borrows money from the lender and pays fees and interest to the lender. And then in exchange, the lender makes their participation in the loan available to the borrower. And then in order to provide protection to sort of backstop the borrower's payment obligation under this loan agreement, the guarantor or whoever the sponsor is backing the project will then effectively guarantee the debt of the borrower to make sure that he promises the lender that if for whatever reason the borrower doesn't pay, they as the guarantor will pay. So this is a fairly simple, straightforward bilateral secured loan facility. If we make that a bit more complicated, you can then find that sometimes, depending on the size of the debt that is in question, it can be challenging for one institution, one banking institution, to be able to provide all of the debt in question. And so what you tend to find is that the loan then gets syndicated. And what that effectively means that you have multiple lenders or multiple financiers participating in the loan and making their taking some form of commitment in the overall debt pie. And so, similar to the last slide that I just explained, rather than having one lender, you have multiple lenders who are providing the loan. That could also even potentially vary. Not only do you have commercial banks or DFIs or export credit agencies either providing direct lending or providing credit support to lenders who are providing the lending, you could also find bondholders or note holders also providing some form of fund. In some jurisdictions, it's often the case now that a lot of private credit funds or institutional investors also tend to join part of the creditor group in order to support lending. And then apart from that, in a syndicated loan concept, syndicated loan structure, you have other parties who also participate in the loan financing. And these parties are there in order to make sure that the sort of administration of the loan sort of goes smoothly. So these are, the likes of your facility agents who effectively make sure that the payments of interest and fees from the borrower gets to the various lenders, and at the same time, the agent makes sure that the lenders make their loan participation available to the borrower, and the agent sort of facilitates that as a conduit. You can also have an account bank whereby, the account bank who effectively holds the account of the borrower into which the cash flows that are generated by the project are paid into, or potentially the proceeds of the facility that are disbursed by the lenders are paid into for the borrower to then access to be able to use towards construction purposes. Sometimes, depending on the level of risk that is involved, or depending on the nature of the interest rate that is put in place, if it's a floating interest rate, in the sense that the interest rate fluctuates and is not fixed, you often find that lenders in a project finance context will require that interest rate hedging is put in place to make sure that the risk of fluctuation in interest rates during the life of the loan is sort of mitigated by the borrower putting in place interest rate swaps or hedging. That's where the hedging banks come into play to be able to make that hedging available. The next topic, having sort of described very briefly what the different debt structures can be put in place in a project finance context. The key question then is what documents would underpin all of these sort of debt structures that we've been talking about in the last few minutes, and what do these documents look like? What are the key drivers as to why they are put in place, and what is their role? And the documents, the transaction documents, can effectively be split into two. You have finance documents, which are the documents for the actual lending, and on the other hand, you have commercial documents or project documents, which are basically the key commercial contracts that the borrower enters into with the different project counterparties that effectively underpin the economic rationale for proceeding with the project. But for the time being, if we stay with the finance documents, there are a number of different finance documents that you tend to find in a project finance context. You don't always, again, have all of them in a project finance context. It will largely depend on the nature of the financing structure that the parties are looking to implement. It could also depend on the nature of the parties who are involved and the financiers who are participating. So depending on who is involved, you might need one or more of the documents that you can find on your screen. Starting at the top there, you have your credit agreement, which effectively is your loan agreement, or your facility agreement, which is the main document that sets out the terms for the lending. You can have where you have multiple parties or multiple group of lenders providing loans to the borrower, and depending on the sort of the objectives or the motivations of each lender group, you might find yourself having to put in place different types of credit agreements for each lender group. And in that context, in order not to duplicate the common terms that are applicable to each of those lender groups, you find that in sort of project finance transactions, parties tend to put in place a document called a common terms agreement. So this document is effectively there to sort of centralize the common terms that are applicable to all creditor groups across the lending platform. Whereas you then have individual loan agreements, which sort of sets out how prepayments of the loans or the repayments of the loan would work as it relates to each individual lender group. So, apart from the lending document itself, you then find that depending on whether the deal is a secure deal or an unsecured deal, i.e., if the borrower will be putting in place a collateral to be able to protect lenders in the event that things don't go well in the project, there needs to be a document that would set out the terms as to how the collateral will be created, as to how the security will be created or perfected in the event that things don't go well. So that is what a security document is there to deal with. Oftentimes, you can also find that lenders do not generally form part of the negotiation or are not party to the commercial contracts that underpin the project financing. And so, say, for example, if you're constructing a power plant, for example, and the borrower enters into a power purchase agreement to be able to sell the power that he generates from the power plant to an off-taker. A power purchase agreement will be entered into between the borrower and the off-taker, but the lender who is providing the financing for the development of the project will not necessarily be a party to that power purchase agreement. And so it is important to for the lender to create a contractual nexus between the borrower and the off-taker to make sure that the lender has a line of sight as to what's happening under that contract, so that if for whatever reason something goes wrong that would require the off-taker to terminate the offtake arrangement, which, as you can imagine, is the key revenue generating contract that underpins the repayments of the lender's loan. So the lender will want to have a say as to, whether there is anything they can do to be able to mitigate the concern that the off-taker is worried about, so that they don't end up terminating the power purchase agreement, which would then have the effect of affecting the ability of the lender to get repaid. So, with that in mind, the document that allows the lender to sort of take that sort of contractual nexus is what is called a direct agreement. So the direct agreements oftentimes get heavily negotiated between the lenders and the counterparties, but is generally a key protection for lenders. I spoke about the need to have sometimes account banks in a project finance context. And the reason for that is, as a borrower is putting in place, sorry. Sorry, can you hear me? I don't know if my audio went off.
We can hear you now.
Hello, can you hear me?
Yeah, we can hear you now, Chinedu.
Yeah, sorry about that. So, in terms of the accounts agreement, so this is a document that effectively sets out the document that regulates how the borrower withdraws money or pays money out of the various accounts it will open up for purposes of the project financing. So if you think about it, the borrower will need to have an account or various accounts into which the cash flow is generated by the sale of whatever the product that the project finance facility produces or sells into. In the same vein, the monies from the facility will need to go into a particular account to enable the borrower use that money to meet construction payments of construction works or some other purposes. So in this instance, you could have different sorts of accounts, disbursement accounts or revenues accounts or proceeds account, depending on whatever it is. And so this account agreement is a document that gives lenders control as to how these accounts are operated, and also imposes certain constraints or restrictions on the borrower as to how he uses monies in those accounts. Because the key commercial rationale for all of that is to ensure that there is no cash leakage, particularly during the construction phase of a project, which is the point where the lenders are most exposed, because the risk of the project is extremely high. The project will only start making money once it is completed, and that is only after construction is done. And so there's a lot of push on the lender side to make sure that there are no cash leakages going out of the project. The next document that you can find on your screen is the intercreditor agreement, or sometimes if you have a security trust structure in your transaction structure, what is called a security trust and intercreditor deed. So an intercreditor agreement essentially is an interlender document, and what is there to do is to govern the relationship between the lenders in terms of how they rank as between themselves in the context of the loans that they are providing to the borrower. It also regulates the votings, how they sort of make decisions as it relates to matters under the loan. It governs how enforcement can be done. It governs how amendments and waivers in relation to the loan facility can be implemented, how votings can be done, and also, more importantly, it governs how proceeds from enforcement of security are distributed as between the lenders and other parties who are potentially involved. I've talked about hedging previously, where you have hedging arrangements as part of your project finance structure. The documents that sort of sets those out is called your hedging agreements, and usually these documents tend to be in standard form, implemented by the Eastern Master Agreements and the sort of corresponding schedule. And so it's there to sort of govern the relationship as to how the various hedging payments are made as between the borrower and the respective hedge counterparties. Other documents can be relevant depending on the transaction that you're doing. For example, you could have accession agreements, you could have subordination agreements if you have potentially sponsors or intra-group lenders who have given intra-group loans or subordinated debt to the borrower. It's important that the borrower's obligation to those subordinated creditors are subordinated contractually to the interests of the lenders, because the lenders will want to rank senior in terms of those liabilities. So that's the document that sort of sets out the terms and conditions for that. The other category of documents that you tend to find that underpins project finance are your key project documents or your key commercial contracts. And again, this will vary depending on the type of project that is being put in place. So if you have like in the example that I raised earlier, a tolling arrangement, a power project, for example, the key revenue generating contract there will be your power purchase agreements, or otherwise your offtake agreement, which would effectively entered into between the borrower who is generating the power and the offtaker who is buying the power. And so this document is very crucial because it is the document that enables the offtaker to pay the borrower for the power that it is buying from the borrower, and then the monies that is paid by the offtaker then goes towards paying lenders and potentially distributions to the sponsors. We talked about supply agreements when we discussed the sort of the key project finance structures, where you need raw materials to be able to produce a particular product from the project plant. Then your supply agreement is very key, and a lot of due diligence goes into making sure that the supply chain that the lenders are lending to is very robust, and that the risk allocation is properly done to ensure that no risk sort of associated from the supply chain would affect the ability of the borrower to produce the product that is required to generate sufficient cash flows. Construction contracts could vary, depending on what sort of arrangement that is contemplated. The simple, most straightforward construction arrangement that we tend to find is where you have a single turnkey fixed price EPC contract. Essentially, what that means is that all of the construction works and responsibility to deliver the project, is sort of resides sort of within one single entity who bears ultimate responsibility. So the risk on the contractor is to make sure that the project is built on time, on budget, and by the relevant specification. And what the borrower needs to do is to just sort of put the keys on and start the project, which is why it's called a turnkey EPC contract. But sometimes it's not always possible to find a single EPC contractor that can wrap all of the construction arrangements into one single contract, and therefore you could often find that multiple EPC contracts are put in place. For example, if it's a road project, you could have a particular contractor in charge of the works contract, another contractor putting in place the steel and sort of the concrete and civil works, etc. So different types of contractors doing different things depending on how what the sort of pricing that the borrower is able to get as part of the overarching construction framework. And so what you then find layered on top of the multiple contract is what is called an EPC management contract, which basically is an individual contractor or manager who sort of oversees responsibility of handling each individual contractor to make sure that they are delivering within the context of their obligations under their individual EPC contracts. We spoke about concession agreements and how that is critical in the context of a government being involved in a project. So this is really key. And the reason for that is if you take, for example, a road project, here the government will give, under this concession agreements, the government could grant a concession for the borrower to be able to construct and operate a project for X number of years. It could be 20 years, 30 years, 40 years. And the idea is that within that period, the borrower should be able to construct the project, make the road project available, and for the government to be able to pay availability payments to the borrower or to the SPV for making the project available for use of the road users. And so it's the monies that then gets paid through the availability payments that the borrower then uses to potentially service the debt and also pay out his shareholders and sponsors. You could also find this document governing royalty payments depending on the type of deal it is. It could be a mining project whereby, a gold mine whereby the government sort of sets out how royalties sort of are structured within the context of the project that is being constructed. In terms of services agreements, it's very crucial to have long-term service agreements, as that's what will be incredibly fundamental to facilitate the long-term sustainability of the project and to ensure that the project is operating as required. We've spoken about O&M agreements at the top of the presentation. Depending on if you're doing a social infrastructure project, say like a hospital under a PPP framework, you could often find facility management agreements whereby the borrower enters into a facility management agreement with a facility manager who ensures that the operations of a hospital or a school is done properly to make sure that the hospital is available for patients to use, and then to ensure that the money generated from the patient's use of the hospital then gets paid to the borrower to be able to service debt and other things. So, having talked about various transaction documents underpinning a project, whether it be on the financing side or on the commercial contract side, the key then is to understand what it takes for a project to be bankable. And when we are talking about bankability, this is somewhat a nebulous concept that you tend to find being used a lot of the time, and actually is very critical because this is what determines whether or not a project will go ahead or not. And I've tried to set out here in simple terms what bankability means in a project finance context. And essentially, if you're able to get lenders or financiers who are willing to finance or bankroll a project, it means that a project is bankable in simple, sort of basic terms. And so, what does it then mean for a project to be bankable? What is bankability? It's not an actual science in the sense that there are no particular sets of facts or factors that you can put in place mathematically to say once we have this sort of various permutation in place, it means that we'll definitely get funders who will be able to bankroll the project. It doesn't always work that way because, from my perspective, bankability is more of an art. And the reason for that is it varies from time to time. What is bankable, what was bankable 2 or 3 years ago may not be bankable today. And I will give you a sort of a clear example of this. About 2 years ago, or 2.5 years ago, they sort of the experience, the trends we were finding in Europe and in sort of rest of the world, particularly in the Americas and in Asia, was this sort of massive shift to a lot of the sort of green energy transition projects and green projects. But in the sort of with Donald Trump coming in and what's happening in the US at the moment, there's been a big shift in that sort of particular sector. And so a lot of the banks that made very hefty commitments towards the energy transition space and sort of their green project initiatives have kind of like rolled back on that a little bit. And some of the sectors that they had totally ignored, particularly the oil and gas sector, have become the bride of town at the moment because people are now sort of coming back to oil and gas and sort of seriously looking into opportunities in terms of gas or gas to power, etc. So, these are some of the things that we are finding. So, even though as some sort of European funders about 2 or 3 years ago may not have found sort of refinery financings or oil and gas financings bankable. Now, it's bankable and people are sort of putting a lot of liquidity towards this sort of projects. And also, it's also highly sector specific. And to give you an example, in Europe at the moment, particularly in continental Europe, there's a lot of drive, largely by regulation, and a lot of the sort of European governments who are pushing for sustainable aviation fuels to be used by most sort of airliners by a certain date. I think potentially by 2040, there's a lot of policies being rolled out to make sure that airlines are using, to the extent possible, sustainable aviation fuels to sort of fly their aircrafts. And so you can imagine that has sort of spiraled huge amount of interest in terms of lenders and potential funders looking at opportunities in the SAF space to be able to promote funding of sustainable aviation fuels. And as a result, we are finding that a lot of projects in the sustainable aviation fuel space are coming on stream fairly regularly within Europe. So again, this all goes back to show that the concept of bankability is fairly fluid. What was bankable previously may not be bankable in 5 years' time. And a lot of this is driven by market sentiment and how big the risk is perceived, et cetera, et cetera. But then why is all of this important? Why and what is the importance of bankability? The reason why bankability is important is that it's effectively the bedrock of the success of project finance. At the basic end, for you to be able to get lenders to come into a project, it needs to be bankable, and this feeds into the overarching due diligence that lenders and sort of sponsors and project proponents tend to put in place. And it is therefore important that risk and rewards are allocated to the party who is best placed to handle them. And so the reason why we go through the pain of sort of doing bankability analysis in project finance context is because it has a number of different ramifications. So for example, if a project is bankable, whether it's on the equity side or on the lending side, it has potential outcomes. So from a debt perspective, it means that if a lender perceives that a project has less risk, then they are able to compromise on the margin that they are going to charge on a project. So they could potentially lower their cost of borrowing for a borrower to lend money, for a borrower to be able to access financing. In the same way, if a lender feels a project is bankable or relatively bankable, then they could increase the ticket size that they might be coming at in terms of the debt size for a particular project. Whereas if the risk is perceived as being, if a project is perceived as less bankable, then if a lender is looking at coming in at a higher ticket before, they could significantly reduce that ticket or ultimately even refuse to fund. In the same way for sponsors or for borrowers, it is important even from a stress testing perspective to make sure that a project is bankable, because debt repayment is one aspect of the equation. The other equation is also your internal rate of return. As a project proponent, as a sponsor, as a borrower, you need to be able to make sufficient cash from a project to be able to not only repay the debt, but also have enough to pay your shareholders or your sponsors who are the brains behind a project. And so fundamentally, bankability is incredibly crucial. And so how do we then achieve bankable? How do we then achieve bankability? What are the things that need to be put in place to be able to make sure that a project is bankable? Well, this is a step that starts at the very inception phase of a project. You don't do it when you're close to taking on loans. You only do it after you only do it at the right at the very start of a project when you're still conceiving the idea. And by that I mean, thinking about what lenders will be concerned about. Because if we think about it, you're walking towards a goal, and the goal is to model or structure a project such that it can attract financing. So what are the things that a lender will be concerned about that might make it sort of not want to lend to a project? So whether it's talking about the robustness of the financing structure, would there be any intercreditor concerns? What is the nature of the security package for the particular project? What does the account structure look like? Are there issues around transferability of currency, transferability of funds from a particular country? Is there a convertibility issue that might mean that a lender who potentially an international financier might not be able to repatriate returns on the debt side, either by way of principal repayment or interest payment? Are there sort of other deeper issues that people need to be aware of? For example, is there project or project risk? For example, if you're doing a project that has interlinkages with other projects on the side, what is the competitive landscape as between those two projects? Would it be the case that a competitor project will be such that the revenue that will be coming towards the project will be limited because of the competition, and how would lenders perceive that from a bankability perspective? So, those are some of the key nuances that come in that you need to be thinking about from a bankability perspective, and try to find ways to work around it. And then once you've sort of thought about the initial phase of some of these, the next thing is how best do you then work closely with the lender and all other stakeholders to be able to address this risk. One way to do it is to start from the very go in discussing with your project counterparty. So whether it's the supplier, or whether it's the construction contractor, or whether it's the off-taker, etc. So whichever counterparty that is critical to getting the project up and running need to consider the bankability of the project and how lenders will perceive it. Because ultimately, if there is no fund to build the project, then there is nothing for a construction contractor to build. So it's important that all hands on deck are on deck to be able to make this happen. And so if it requires you to start having conversations with the relevant project counterparties from a sponsor perspective to, for example, get them to understand that there might be need to have a direct agreement to give lenders some comfort in terms of having some form of direct contractual nexus with the relevant project documents, then that needs to start happening. If there is need to get the relevant project counterparty to give upfront consent for a borrower to assign his rights under a project contract or a commercial contract in favor of the lenders to facilitate enforcement, then again, it's important to start having those conversations earlier, because that goes into the overall bankability analysis. And then we've talked briefly about what makes a project bankable. I've set out on the screen a few sort of ingredients that I think are helpful tools. But again, these are not one size fits all tools. There are a number of different factors. It's not often the case that you will need all of this, but you will get closer to having a bankable project if you have most or if not all of these ingredients, one of which is a robust and effective and efficient legal framework. I mean, this goes without saying, because fundamentally, if you have a fantastic legal regime that facilitates ability of lenders to be able to bring in money and take money out, if you have a legal regime that allows them to enforce their rights if something goes wrong in the project, that will be amazing for them, and lenders will be able to lenders will be zoning in through their due diligence to make sure that the legal framework where the borrower is based is watertight, or at least would allow them to reach a bankability stage to be able to invest in the project. Otherwise, the project will not fly. You also need to have a good project. I mean, that goes without saying, because if you have a project that doesn't really stand the test of time, then no matter what you do, no lender will provide funding to it. So that goes towards the structuring as well. And I think from a sponsor's perspective, a lot goes into the thinking in terms of what actually makes a good project. And some of the things that we've talked about will go a long way in addressing those concerns that lenders have. Reliable counterparties, obviously, is another ingredient. For example, if you have commercial counterparties that are creditworthy, that are not subject to sanctions or sort of anti-money laundering constraints, or some of the sort of policy issues that a lot of lenders are worried about, that would again go a long way to making a project bankable. Experienced sponsors is also another thing. If you have a fantastic project, but the people backing the project or the people sitting behind it are vastly inexperienced, that will leave a massive question mark on the ability of the project to be banked. And so, this is where lenders will start thinking about having some form of completion support or other sort of credit support to be able to ensure that any risk of the sponsor, either because they are inexperienced or because they are not credit worthy, is adequately mitigated. A reliable revenue stream is also another critical one, because effectively, you need to have a good revenue stream that will be sufficient to repay the debt at the very least, and also fundamentally pay some decent dividends or distributions to the project proponents, because otherwise there's no need, there's no commercial rationale for the sponsors to go ahead with the project. And fundamentally, there will be no need for the lenders to even bother financing the project if there are doubts as to the ability to recover on the debt side. A smart financing structure is what we've been talking about in the last few minutes. It's important to make sure that the financing structure is sufficiently robust, and even where you can't really address all the risk, but as long as you get the risk sufficiently mitigated to a point where the various credit committees of the lenders are reasonably comfortable that a project can go ahead, then I think you've done a good job in that regard. Again, this is just a slide that basically shows the different project parties that participate in the project and how each one of them could potentially be allocated risk on a particular project and have responsibility to deal with those risks. All we are saying here is that risk allocation is a critical part of bankability analysis, and we will come on to shortly a very simple principle-based approach as to how risk can be allocated and who is best placed to deal with those risks. Right, so now that we've talked about bankability and what it means and how risks are a critical part of sort of structuring a project finance transaction and how it is critical to allocate the risk effectively to make sure that the project gets to a stage where we can get lenders to be able to bank it, then the question is, how do you do risk allocation? What are is there a methodology that a borrower or sort of other project participants can adopt to be able to do this? And I think what I've put on the right-hand side of your screen is a fairly simplistic approach that Abraham Hansen, a leading academic on construction contracts, have put in place to be able to sort of determine how risk can be allocated. And essentially, what he said was that you should allocate a risk to a party who is best placed to bear that risk, i.e., either because that party has sufficient control of that risk. So to give you an example, if a contractor is building a project, then fundamentally the construction of the project is well within the control of an EPC contractor. And so any construction phase risk, should well and truly sit within the grasp of an EPC contractor, because they will have full visibility on the ability to construct the project on time and on budget and within the required specifications. So what Abrahamson is saying here is that risk should be allocated to a party risk should be allocated to a party where such risk is fully within the control of that party bearing it. The other one is, if a party can effectively transfer out, either potentially by way of insurance or by way of reinsurance, the relevant risk, then that party is best placed to bear that risk. And to give you an example, if under your EPC contract there is third-party damages or potential construction risk or delay in startup risks associated with the project, then to the extent that the borrower or the contractor can put in place insurances at the back end to be able to mitigate those risks, then firmly and truly those risks will sit either with the borrower or the EPC contractor. On the debt side, sometimes when you have export credit agencies participating in a deal, either by way of direct lending or potentially providing insurance or guarantee coverage to lenders who are providing the funding, then in that instance, the export credit agencies will be coming in to say to the lenders who they are covering that if for whatever reason the borrower is unable to pay following the occurrence of an event of default, or if something goes wrong with the project, then we as the ECA will pay you. So, and then the ECA is able to do that because at the back end, they are able to reinsure that risk with their sort of back-to-back reinsurers who sit behind the scenes. So again, to coming back to Abrahamson's principles here, the point is that if you have a party who is able to transfer out that risk, either by way of insurance or reinsurance, then that party should be bearing the risk. The other principle, it's if a party has the greatest economic incentive to assume a risk or control a risk, then the relevant risk should sit with that party. And this often comes when it relates to completion risk. So obviously, lenders always worry on whether a project will actually reach completion, because if you think about it, the project is not generating any cash flow until it reaches completion, except in limited circumstances where there is some pre-completion revenue, either because the project is able to make some money by selling power if it's sort of at a completion testing phase just before completion. So that in that limited instance, it can generate some revenue, but even then, the pre-completion revenues are fairly limited. So effectively, lenders are worried about completion risk, and they want to make sure that the project is completed, because that's only when monies will start coming into the project to go towards repayment. And during this period, the lender's view a lot of the time is that until the project is completed, it should be the fundamental risk of the sponsors to bear the risk that a project doesn't complete, and therefore they should be putting in place some form of completion support or debt service undertaking. I.e., if the project doesn't complete, we as the sponsors will pay you the debt that is outstanding at the relevant time. And the reason for this is simple. The sponsors are the ones who benefit from 100% of the upside if a project gets completed, because fundamentally, then they can start getting revenues. They can start giving revenues into the project, and all of the dividends that sort of come after debt is repaid gets paid to the lenders, to the sponsors. So that is how that is why Abrahamson has sort of put out this particular line of principle. And then also to sort of fast forward a little bit, if a risk, if it's practical, if it's not practical or sensible to allocate a risk to somewhere else or to transfer a risk to somewhere else, the risk should go to the person who obviously should bear the risk. And in this instance is the owner of the project, who are the sponsors. So if for whatever reason the lenders have tried a lot of risk allocation tools and risk mitigation measures to be able to transfer out a risk or allocate a risk, the ultimate responsibility for any unallocated risk will be the project proponents or the sponsors. So again, that's a fairly simple risk allocation tool that comes to mind. So to just sort of wrap up fairly quickly, some of the risks that you can see on your left-hand side, completion risk, is a project able to complete on time and on budget? This typically sits with the construction contractor. Is the project ever even going to complete? Again, this sits with the the sponsor. How about operations? So once we've gone past the construction phase and the project is now generating money, the lenders are still worried because they want to make sure that the project continues to operate properly and optimally to be able to generate the amount of cash flows that go towards repayment. And so it's important to make sure there's a robust operating and maintenance arrangement in place by the borrower to ensure that the project is operating properly. And so where this were to happen, depending on who takes on the O&M arrangement, be it the borrower or a third-party O&M provider, then that particular party will bear the risk of any operating risk. In terms of revenue risk, i.e., the lenders are also worried on whether the project after completion will be able to generate the amount of cash flows that have been sort of modeled in the financial model that underpins the base case for the project. And therefore, here, the lenders are worried that, to the extent there is insufficient revenue, who can we get recourse from? Who can we sort of try to get some protection from? And then on this particular one, this will largely depend on the revenue story. So where is the money from the project coming from? If the money is coming from, say, an off-taker under a PPP, under a power purchase agreement or some other off-take agreement, then lenders will be looking at the off-taker to make sure that the off-taker is creditworthy and to the extent required, make sure that there is sufficient credit support that will backstop the payment obligations of the off-taker under the off-take agreement to make sure that the monies continue to flow into the project to then enable the project repay the lenders. So whereas if there is no sort of long-term off-take arrangement, and instead the borrower is faced with merchant risk or having to sell the products produced from the plant in the sort of open market, then that creates a different type of risk because fundamentally there is no guaranteed revenues coming in. And so in that instance, the lenders will be looking at the sponsors or the borrower to plug any revenue gap if for whatever reason the spot sales are not coming through properly. In terms of legal risk, as you can find on the scheme, this sort of relates to the enabling legal environment that we were discussing about a few minutes ago. Is there change in law risk? Is there change in tax risk? Typically, as some of you may know, change in law risk tends to sit with the government, predominantly because they are best placed to control and manage change in law risk. So for a project where you have government involvement, this sort of sits tightly with the government. And also, change in tax risk as well. Sometimes lenders tend to accept sort of general change in taxation risk, particularly if the relevant change in tax is something that is potentially foreseeable and the lenders are able to price in any incremental cost that will be associated with the tax into their pricing for the deal, or potentially seek recourse through other protections within the credit agreement, such as your tax gross up or increased cost provisions in the loan document. The same can also be said about political risks. If there are political risks in the country, a lot of the time, depending on whether it's prolonged political risk or not, this sort of largely sits with the government. And therefore, if for whatever reason that sort of happens either by way of a project where the government were to seize a project or to sort of effectively take over a project from the project sponsors, then effectively that is a risk that the government should be bearing, and so should be paying termination payments under whatever the project agreement or concession agreement is. And effectively that termination payment should be sufficiently sized to at least cover the debt and sometimes equity. So in a nutshell, these are sort of common risks that we tend to sort of find in a project finance context. And then just a couple of final words to say on this, because I'm conscious that we are running close to time for Q&As. It's not in every instance that you could get rid of all the risk associated with the project. Sometimes you can identify a risk and you're not just able to get rid of the risk. And where you cannot transfer out the risk, that risk would ultimately sit with the sponsors or the borrower. And then if it's impossible at times for lenders to get rid of a risk, and depending on the scale of that risk in the bankability analysis of the lenders, the lenders can decide to do a number of things. They can decide to, reduce their participation in the loan in terms of ticket size. They could try to build in some very robust contractual protections within their finance documents. They could also potentially, look to build in some economic sort of incentives, be it by way of margin ratchets if certain things happen, just to sort of cater for the incremental risk that they are taking. Or in a worst case scenario, they could just completely not lend at all. So again, different types of mitigants can be adopted depending on the sort of the scale of the risk and the degree at which the relevant risk will materialize for practical purposes in the context of the project. But also on the lender's side as well, regardless of all of these risks, it is important that lenders do very robust due diligence. And this is where we as lawyers come to play. So in a project finance context, there's a lot of robust due diligence that go into reviewing the underlying commercial contracts, making sure that the diligence that is done on the project feed into the actual loan agreements, not just to protect the lenders, but to also give the borrower key protection vis-a-vis its project counterparties to make sure that it is not accepting risk or obligations from the lenders that it is unable to offload through its commercial counterparties. So there's a lot of balancing that needs to be done from a due diligence perspective. And then finally, the lenders, when all the chips are down, need to also make sure they do their own sort of downside sensitivity analysis to make sure that in the worst case scenario, the financial model, the base case financial assumptions that they've done internally with their credit committees is such that even where all of the risk that have been identified haven't been fully allocated or addressed, the project is still enough to provide funding to such that it justifies moving ahead with the project. That is it for me. I know that was an absolute quick canter through of what is effectively a very broad area of law, but I think I'm sure there's a lot of burning questions that people might have whilst we're going through, or whilst you've been sort of digesting some of this stuff that we've been talking about. So I think Tpta, if you want to open the floor for Q&As, and one point to make is, even if ultimately we don't get to answer all the questions because of we're running out of time, we will be happy to aggregate questions to the Tpta team and the NLNG team, and we can provide responses in writing later.
Thank you very much, Chinedu. I'll just say a few words and then I'll hand over to Idris Mohammed to superintend the question time part of the session. But Chinedu, thank you very much for a very incisive and insightful presentation. I'll just say to the delegates that it's important that I acknowledge at this point that Chinedu has just presented this session at no cost to Tpta, the MBA, or indeed to anybody. It's totally a pro bono session. And I think that having practiced myself in England, I know how precious time is and billable hours are and what is taken for him to do this. And I think it's important that we acknowledge the fact that he's given back to the legal profession in Nigeria, and he's done so well. So Chinedu, thank you very much. I also want to acknowledge the contributions of the legal team of the NLNG and the NLNG Learning Academy, from the General Counsel, Akamo Kede, to Lois Oni, to Olayinka Ajose, and the entire team for helping to facilitate the session and collaborating with the Tpta on this. So thank you very much. I'll say formal thank yous at the end, but in the meantime, I'll invite the Director of Operations of the Tpta, Idris Mohammed, to run through question times. Thank you.
Okay, thank you very much to Bena, and also thank you very much, Chinedu, for that very solid presentation. You have taken us through the fundamentals of project finance in a very clear way. We have looked at the particulars and the rules of various participants, the importance of the structuring through an XPV. So we'll now move on to the questions and answers segment. And as previously stated, it is an opportunity for the participants to engage further on the issues that have been raised during the presentation. Now, if you have questions, we have a couple that have already been put into the Q&A session in the Zoom platform. If you have any further questions, I would ask that you please put them through as quickly as possible. We have limited time for this, so I'll go straight into it. I'll be picking the couple of questions in the way they came in on the Q&A segment of the platform. The first question we have here, Chinedu, is from Vivian. And she says, with respect to security package / collateral, what is the industry norm, in bracket international, for construction of a modular refinery gas to liquid project by an SPV?
Yeah, thanks for that. I think in terms of industry norm, I would say there's really no standard form security package. It all depends on a number of variables. It depends on the strength of the sponsor. Sometimes a lot of the sponsors tend to get away with certain things if they are perceived in the market as being creditworthy. But for a project finance context, I would expect some basic forms of security. For example, an all asset security over the modular refinery that is being constructed as a starting point. A lot of the times, lenders will always ask for a share pledge, a share security over all of the shareholders or the sponsors' shares in a project to be able to facilitate enforcement. And then, account security is always very critical because, before you sort of go through the hog of selling bits and pieces of equipment or land or anything like that, lenders would already want to take over monies standing to the credit of the project accounts, and then sort of intercompany loans and assignments on the contract. So those are the kind of like typical security that you find. But again, it's important to emphasize that there is no one size fits all security package. It all depends on the what sort of degree of comfort the lenders are getting. If the lenders are getting sponsor support by way of a corporate guarantee that layers on top of your security, then they tend to be fairly relaxed, because whatever happens, depending on the credit worthiness of the sponsors, they will get repaid. So they can take a bit of a relaxed view on the security package.
Okay, thank you so much for that. And okay, the next question is still on the same SPV structure, and an anonymous attendee is asking whether it is possible to have a project finance arrangement without incorporating an SPV. And as a follow-up to that, it's also saying, must the SPV be a limited liability company?
Yeah, that's a really good question. In terms of the whether you can do a PF without incorporating an SPV, there's a structural reason why an SPV is important, and it has to do with the fact that lenders always want to put money in a vehicle that is bankruptcy remote. What that means is lenders want to put money in a vehicle that don't have sort of existing liability, or a vehicle that already has indebtedness from all over the place. They want to be able to put money in a vehicle that is clean, such that it sort of facilitates the ability to enforce security in a downside scenario. And so the way to implement that is obviously by having a freshly incorporated limited liability company. But again, it doesn't have to be a limited liability company. There could be potentially other structures, but that's typically the most common structure that we tend to see.
Well, thank you again. Chidima is thanking you for your solid presentation, and she asks who executes the direct agreement? Is it the lender, the borrower, and the off-taker? And also, as a follow-up to that, she's also asking, are the off-take agreements and the direct agreements executed before the lender finances the project?
Thanks for the question. So in terms of the parties to a direct agreement, yes, you're right. It's typically the borrower, i.e. the project company, the off-taker, or whoever the counterparty is. It might not be an off-take contract. It could be a gas supply agreement. So in that case, it will be the gas supplier. And then the lender representative. So a lot of the times in a syndicated financing or in a club deal where you have multiple lenders, is administratively burdensome to have all the lenders entering into a direct agreement. So what typically happens is that the lenders instruct and empower the intercreditor agent to be able to enter into the direct agreement for and on their behalf. So that way it's easier to just have one entity signing up to the direct agreement as opposed to multiple lending parties. And then in terms of the timing points, usually direct agreements are entered into after the lenders have come in. So it's typically a condition precedent to lenders funding the borrower. And the reason for that is a lot of the time, the underlying project companies would have probably been signed well in advance without the lender's involvement. And so when the lenders come, rather than looking to amend an existing commercial contract that's already been signed up, so what they normally do is to try to negotiate some of the key protections that they need to be reflected to make the project bankable, to then facilitate lenders putting money in the project by way of the direct agreement. That's why it comes after.
Again, thank you so much for your always brilliant and insightful answers to these questions. The next question we'll be dealing with is from Wuyi Showe Mimo, and he's asking, are there potentials in other sectors other than more traditional sectors, such as entertainment industries with major movie potentials as large commercial projects?
So it was a question whether you have you could adopt sort of project finance in the entertainment sector industry.
Yes.
I think Sorry, go ahead.
Yes, that's the question.
Yeah, I think it would depend on what is it that we are building. Like, if you cast your mind back to the first slide, in terms of what is project finance, it's the development or the construction of an asset or a right. So there needs to be a tangible asset being constructed for us to say we are financing a project. And so if it depends on what it is in the entertainment sector, if it's sports stadium, if we can call that entertainment, or a theater, then there is a tangible asset being constructed that can be potentially project financed.
All right. Thank you so much. So now I'll be looking at, there's this particular question um, that I think is quite important. Yeah. So it goes like, given the complexity and the long gestation period of many project finance transactions, how do law firms typically approach billing for this kind of work in a way that remains commercially viable for the firm while still acceptable to sponsors and lenders? The reason I am curious about this is my firm is presently involved in one, and we have taken a lot of time in trying to convince the clients about our own bill. So I would really like your insight into this.
Yeah, that's hitting a very sensitive topic. But anyway, I'll try to give that a go. I mean, I think fundamentally, project finance transactions are notoriously long. I was sort of in my career, I was involved in a particular project that ran up to 10 years and count. So sometimes you can find those sort of really extreme scenarios, and then you're asking yourself, how do you bill, or how do you sort of budget for that? And I think typically law firms have in their quotes assumptions that are time bound. So basically, you address that through time assumptions. You bill or agree fee arrangement based on certain time periods, such that after the expiration of those times, you either enter into good faith discussions to be able to agree sort of adjustments to your fee quotes, or sometimes we tend to see other fee arrangements where people also build in sort of monthly fee cap arrangements after the initial fee cap period expires, just so that they don't have to always go back to the client to be able to sort of renegotiate fees. So, but again, fundamentally, it will become obvious to all the parties involved, particularly if a deal drags on so much that there needs to be some form of conversation to be had on fees. But I think in all of this, the key is making sure that there is periodic fee updates given to the clients, so that they are not caught unawares in terms of how sort of the cost overrun on the matter have come about, or how you sort of ramped up on fees. And the reason I say this is I've had an experience on a deal in Burkina Faso, where basically it was a relatively small deal, where basically the capex cost of the solar power plant is sort of smaller than the fees that were incurred in the deal. I mean, it's absolutely staggering, and there was a lot of back and forth on that. So it is important always to do regular fee updates to keep the clients informed.
Yeah, thank you. Just a quick follow-up on that. When do you consider the best times to discuss fees? Right from the beginning? So sometimes you might not even know the time structure, or should it be an intermittent and regular discussions? Or just give me from your own experience the best times to have those discussions.
Well, in terms of fees, obviously, when you quote for a project finance work, you would have submitted a fee proposal in the initial phase of responding to an RFP of the instruction. And so at that stage, you're already putting forward your best foot forward. And if for whatever reason the client wants to negotiate the fees or wants you to come down or etc., that will be done at the preliminary phase. I'm assuming your question is more sort of once you enter into the deal and start advising, and then you're ramping up fees and you want to have fee discussions. I think you can't really have fee discussions until a fee assumption within your engagement letter is breached, or at least you're getting close to breaching it. So you can always find a way to do a soft email to a client to try and inform them that FYI, you think that the scope is massively increasing or that you're blowing up your timing assumption and that at some point it will be worth having a discussion on fees. Just the key is good communication and keeping the line open. But there's no hard and fast rule in terms of when the actual discussion on fees should start.
Thank you so much for that. So since almost all of us on this webinar are lawyers, there's this particular question that that says that at what point in the life of a project do lawyers add the most value? Is it during early structuring, documentations, or negotiations with lenders? I would probably say throughout, right?
Absolutely. You add value throughout the life cycle of the project. So if you cast your mind back to the cradle to grave slides that I shared earlier, the real value as lawyers, as transaction lawyers, is essentially, the value you bring at the inception, like when the borrowers or the project sponsors are thinking about the project from a structuring perspective. You need to stress test a deal at initial stage to sort of having the lens of the full project cycle to see how the lenders or different project participants will extract value from it, because that's how you become the cream of the bunch in terms of your value add and you being able to put yourself in a great position to be able to win the mandate. If your relevance is only during the construction phase or during the due diligence phase or the operation phase, then you're not going to be as attractive as someone who can provide full service across the entire value chain. So to your point, I will absolutely say throughout the project.
Yeah, thank you so much. So I'll just merge a couple of questions as relates to building careers in project finance advisory. They go. They are recurring questions. What do they need? What do young lawyers need to do if they want to build a career in project finance advisory? Maybe reference to books or there's a particular question that was framed in such a way that without going into the formal four walls of a school, how can I improve myself? So if you can just give a general overview of if a young lawyer is interested in a career in project finance, what does he need to do?
Yeah. Well, that's a really good question. And actually, I think you're right, and many thanks to the Tpta and the Nigerian and NLNG for sort of putting in place this platform to sort of enable young lawyers to get this exposure, because unfortunately the legal curriculum in Nigerian law schools or universities don't go as far as sort of equipping students or lawyers with sort of special expertise in specialist areas like this. So I think there are a lot of useful resources online. For example, I know that the International Finance Corporation or the World Bank have like free to access legal resources on their websites on project finance or bankability or understanding risk allocation, etc. So people can always access those platforms and other platforms, not just the IFC and the World Bank, but other different platforms, or more generally, general resources available on the internet to be able to read up on it. And obviously from time to time, and hopefully with the curriculum that we've put in place for sort of Nigerian lawyers, there's a lot more education that can come through that people can benefit from.
Yeah. Thank you so much. So just to close up before Tpta comes back to give his vote of thanks, your firm and yourself seems to have been involved in a lot of projects in Africa. But as you know, Africa and particularly Nigeria have enormous infrastructural needs, yet many of these projects struggle to reach financial close. From your own perspective, what are the biggest structural barriers to project finance, particularly in Nigeria and also on the continent of Africa?
Where do we start? We probably
Sorry about that.
I think there are a number of different structural issues. Nigeria have come a long way. I wouldn't necessarily say that there's not a lot of deals happening in Nigeria, because of course there is a lot of deals happening in Nigeria, and we encounter a lot of, I'm sure, members of the audience on a number of these deals from time to time. But I think there are a lot of structural issues that still need to be fixed. The one sitting at the top is sort of enabling legal framework. There's a lot of question marks over the extent of government support for a number of these project finance deals, and to what extent governments even really have the capacity to do that, which is why you see that there's a lot of sort of lovely products that have been put in place to be able to address risk around political and commercial risk and insurance, such insurances and guarantees, etc. You also find issues with financiers looking for good projects. A lot of people say they have projects, but half of those projects are not really bankable. And you've seen some of the key issues that underpin bankability that we've already discussed during the course of this presentation. So, there are a number of key factors that go towards having a successful project that various parties will be willing to enter into. Most recent of which is, the issue with not so much of an issue at the moment, but there used to be a time when currency convertibility was an issue. For example, you couldn't repatriate dollars out of Nigeria on deals, and that was a big problem for lenders, or currency transferability, or all of that. So there are a few structural and also sectoral issues within specific sectors that need to be looked at and are continuing to be looked at. But I think there's still a long way to go.
Okay, so thank you very much. I'd like to apologize that we cannot take all the questions that were in the Q&A session, that were put in the Q&A, but be rest assured that, as Chinedu said, we'll compile all these questions and probably send it out to him, and he will probably send in answers on them. So having said that, thank you so much, Chinedu, for answering those questions. Very deep and very insightful and very, very solid. I'd like to call Tpta back to give his closing remarks. Thank you.
Yeah, thank you very much, Idris. I mean, Chinedu, what an exciting and interesting presentation. I mean, there were certain aspects of it that actually took me back in time. I particularly enjoyed the analysis around bankability, because it reminded me of when I was working on, a number of project finance deals on urban regeneration during the recession period that was in England, and projects that were considered bankable and very viable and were moving on suddenly became non-bankable because of the cost of property prices and all the assumptions that were made initially. So most of the lenders were reluctant to continue lending, and so many things went wrong. And we found the government intervening with all sorts of gap funding arrangements just to make sure that the projects return to viability. So I particularly like that analysis. And then that same scenario also fed into the question that one of the participants asked about long term of projects and the fees. And you found that even when projects were stalling, lawyers still had to be in the room to negotiate through things, draft new contracts. Everybody was trying to save the goose that laid the golden egg, which is the project itself. So thank you, extremely insightful, very interesting presentation. Well done. And I say to everybody again, we just need to express our gratitude to Chinedu for the time he spent putting together a very comprehensive curriculum. I just want to remind everybody, because when he was talking about the resources available, that this particular session is actually on Tpta's YouTube channel. And if you subscribe, you'll be getting, you'll have the ability to then watch this session again whenever you need it. And so Chinedu, it's an end-to-end. I mean, just in 2 hours, you've been able to take us through so much in the project finance cycle. And I think this is really great. Thank you very much for your help, for your support. And I hope that everybody here and all the in-house counsel that we also invited, and the ones who don't know you before, I mean, all the ones that came back to me said, oh, solid. I hope that the rest of them also see the value that you brought to this presentation and the knowledge. So thank you very much, and God bless you. I also want to thank the team from NLNG once again, from Akawon Kede to Lois Oni to Alainka Ajose. And also want to let the participant know that, of course, this training is MBA ICLE accredited. And then over time, working with Chinedu and NLNG, we'll come back to you on when we're going to have the next module and the next module and the next module until we get to the end of it all. Chinedu and his team are determined to make sure that they tell us what we don't know. So thank you very much. Then just to also inform you that on the 18th and the 19th of this month, Tpta is going to have a AI prompt engineering session delivered by a very solid faculty also. So just look out for the advert starting from this evening. So Chinedu, thank you very much once again. And we look forward to having you back again like Oliver Twist. So God bless you. And
Thank
then,
you.
Okay.
Thank you so much, and really appreciate the time and the audience. Really appreciate. I hope you enjoy the rest of your day.
Thank you. All right, guys. See you soon.
All right.
Bye-bye.